Law Simplified with Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Maduforo, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the individual rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
Bring it to your doorstep and simplify it the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.
Hi, Susan from London. Hi, Susan. Welcome to Law Simplified with Justice.
Hello.
Hello, Susan. You're welcome to Law Simplified with Justice. Can we have your questions?
Yeah. I'm just wondering. You're talking about criminal convictions.
Yes, please. Go ahead.
Yeah. Can you hear me?
Yeah, I can hear you perfectly well.
Okay. You're talking about criminal convictions. Someone that had a driving conviction in 2008, sometime June 2008, and was fined and has paid the fees since 2008, and is making an application now in 2011. How does that affect the person?
Right. Okay. The person made the application in 2008, you said?
Yeah. The person, yeah, has made an application.
In 2008?
Yeah.
But he hasn't, no response from the Home Office at the moment.
Pardon?
No response yet from the Home Office. The person has not received any response from the Home Office.
I can't hear you.
Are you saying that the person made this application in 2008?
Yeah, the person has made an application before now and has been.
Has been what?
The person has made an application before now and has been refused.
Right.
And it's being reviewed now at the Home Office.
Right.
The person had a conviction in 2008, driving conviction, and was fined. Yeah, but he has paid the fine in 2008.
Right.
Yeah. But
okay.
His case is being reviewed now,
right.
2011.
Okay. Thank you, Susan, for that. The question now, the issue is that you've got a fine. Now, the issue about the fine is that this happened prior to 6th of April 2011, so which is a very good age for him. So the Home Office will determine that application based on the pre-existing situation, circumstance then. So they will not apply this 6th of April changes that have come in. So his conviction in 2007, 2008, having applied for a review, and if the Home Office is reviewing that, and definitely will not be caught up with this 6th of April 2011. So that means the application will be considered under the pre-existing status then, not from the 6th of April. So the application can still go on. They will use the conduct criteria, they use the circumstances criteria to see whether or not that application or the offense committed could warrant them to refuse, but definitely not under the 6th of April 2011 new rules. If it's under the 6th of April 2011 new rules, that means that application will be refused automatically. But as I said, the application is being considered prior to 6th of April 2011, so they can carry on with that. But if the person comes subsequently, that review is subsequently refused, and then the person makes another application after 6th of April 2011, that means you'll be caught up with that. I think that's a fair explanation to that.
That's spot on. And just to add to that, I think really what she didn't say to us, perhaps you don't want to tell us now, but other reasons why it was refused. Because
obviously.
It couldn't have been only the criminal conviction aspect of it.
Yeah, there might be other things as well.
And that is why it's always important to seek legal advice from a professional, from someone who understands the law, who understands how to apply the law, and what is the reason why we go to law school, to be able to understand, be able to interpret it, in order to assist our clients. So always, immigration law is not what it used to be. Back then you can obviously do it yourself and chance it and with
the DIY structures are fading away. So the laws has been so much scrutinized and strengthened, and they are repealed, amended to such extent that you need an expertise knowledge in order to really fine-tune what these changes are, in order to give a much better advice and don't do it again, because that's what it means.
That's it.
Although the DIY people still structure on there, obviously part of the cost. Now, going on cost issue is a very important thing. There's a lot of changes in this application. The cost has been rising astronomically. The last period, the new fee now, I understand, if I'm sure I'm wrong, it's £972, and that's for an individual for post. And then the dependent. So if the dependent is joining, it will be £468 per individual. That's astronomical.
Well, that is exactly what I said from the beginning, because which is why sometimes people say penny wise, pound foolish.
Absolutely.
So why do you have to chance 1,000 plus when you can get advice to be able to understand, making sure that it's done properly, and seeking advice from well-qualified practitioners. And if things go wrong, and if there's reason for you to complain, at least you know where to complain to.
Absolutely.
And there are bodies there who are able to actually assist in relation to if the solicitor or the immigration advisor failed to actually carry out the job properly.
Absolutely.
And when you look at the amount involved, does it worth chancing it? Certainly not.
That's correct. And to go back to the issue about what they call, asked initially about the rehabilitation period. Now, the rehabilitation period it's not at the period where the conviction, where the person spent it. The time start running when the conviction actually took place. So, assuming the person convicted on the 6th of, let's say this is July now, the person is convicted on the 10th of July. And the conviction spent period will start running from the date the person was convicted, not from the time the person has spent it. So period of spent starts from the period, assuming we said 6 months, so from 6th of July, and that means that for the 6 months period start from the 6th of July. That means the person must have to spend that conviction from 6th of July till the 6 months time coming before the person cannot consider and be able to make the application. I think the key, very major key change to this application is about this criminal conviction. Now, on this show, we'll be talking about sometime again in criminal law, to be discussing, to bring on the show criminal laws and see how people can understand a way to avoid this. And there's quite a lot of areas that, especially the ethnic community, and we really want to bring in some key issues there in criminal law to discuss and dissect a little bit how people can avoid, falling into pitfalls of these criminal convictions, which definitely affects you along the line. Now, indefinite leave to remain, obviously you said, quite different from that of indefinite leave to enter. I mean, people don't understand what the difference is between indefinite leave to remain and that of to enter. Both are indefinite leave, indefinite leave.
Well, that's correct, obviously. Well, again, that's the thing, leave to enter. The difference, of course, is that indefinite leave to remain is simply the application when you actually made in UK.
Right. To
remain in UK. And indefinite leave to enter, perhaps you're applying from overseas. So from embassy or from abroad, and perhaps you qualify under, say for instance, the marriage, you and your spouse perhaps have lived overseas for 4 years and you qualified, then the embassy officials, who call it entry clearance officer, they prefer to be called as a sexy name.
Yeah, absolutely.
And they will not actually give you leave in a provision period because you have actually spent that in your home country. They will give you, a settlement, which is the leave to actually enter, which is allow you to, live here and do the same thing as someone who has indefinite leave to remain.
Right. Okay. And obviously, talking about that in terms of the differences we have on there, we've gone to streamline the two differences there in terms of the indefinite leave to enter and the indefinite leave to remain. These are two the same, but obviously speaking the same voice. In terms of what is the meaning, comes down to the fact that you've been authorized and permitted to come into the United Kingdom to live permanently.
Law Simplified with Justice, the new informative, educative, and thought-provoking program is what you need to keep abreast with law and politics. This exciting and truly refreshing program is anchored by Justice Maduforo, a solicitor.
Ladies and gentlemen, it's been a soul-searching discussion here with my colleague. We've been dissecting sole responsibility under the individual rule, those under 18 and those above 18 years of age as well.
Law Simplified with Justice understands that law is a powerful driver to human behavior. It is therefore poised to simplify the law and get you to take action.
Bring it to your doorstep and simplified the way that you will understand.
Contact Justice by calling 07931 727 597 or email lawsimplifiedwithjustice@yahoo.co.uk. Law Simplified with Justice, bringing the best to the audience.